Welcome to Personal Injury Marketing Minute.
Welcome to the Personal Injury Marketing Minute, where we quickly cover the hot topics in the legal marketing world. I'm your host, Lindsey Busfield, the Vice President of Optimize My Firm. Today, I'm joined by Elizabeth Kayatta, a trial attorney and shareholder at Berman Simmons, a firm known for handling complex catastrophic injury cases across Maine and Massachusetts. Elizabeth has secured record-setting verdicts and settlements, including the largest trucking accident settlement in Maine history. Today, we're talking about how legal strategy shifts depending on who you're trying to persuade, whether that's a jury, a judge, or an insurance company, and why one-size-fits-all advocacy often fails. Well, thank you so much for joining us today, Elizabeth.
Thank you, Lindsay. Thanks for having me.
Well, talk to me a little bit about your background and your practice.
Sure. So I was born and raised in Maine, where I practice now. I originally started practicing down in Boston, and it was practicing in Boston that I really discovered my passion for personal injury and medical malpractice plaintiffs' work. There's something about being aligned with your client and really wanting to achieve the best possible result for someone who has been injured through no fault of their own. That's a cause that's very close to my heart, and it's a cause that I have really dedicated my career to pursuing. So when I had to decide where to spend the rest of my career, I knew that I wanted to come home to Maine to be not just close to family, but close to the people that I had been raised in this wonderful state where I am lucky enough to practice.
That's wonderful. And I think that there are so many personal injury attorneys out there who can relate to that, because everybody gets into this practice because they want to help people, because they want to make a difference in the lives of their clients. And with that comes a certain level of empathy that you absolutely have to have in order to do the job right and to serve your clients well. You need to not only have empathy and understanding for the perspective that your clients have, but you also need to understand how to speak to different audiences, including your clients, but also to judges, juries, as well as insurance companies. And that's really what we're here to talk about today, is how to transition your strategy and your approach using that empathy to develop the best possible strategic case based on who you're talking to. So, Elizabeth, tell me a little bit about your process when you begin preparing for a case. How early do you start thinking about who the ultimate audience will be, whether that's a judge, a jury, or an insurance company?
Sure, that's something you've got to think about from the very first phone call or web form submission that you get. I am a trial attorney at heart, and so every case that I'm working on is with an eye towards ultimately, will I be presenting this case to a jury, to a judge in a courtroom? That really controls how I work up these cases, because you have to think about not just what's going to succeed with an insurance adjuster or an opposing party, but you have to ultimately prepare the case in a way that is going to succeed if you end up presenting it to a jury. And I know that there are a lot of personal injury firms that will divide according to pre-litigation or post-litigation, and that's a model that definitely succeeds for a lot of firms. The firm where I practice, where I'm a shareholder, Berman Simmons in Maine, we really take on every case with an eye towards it being one that will go into litigation, that will end up trying. We're a group of exceptional trial attorneys, and that really guides how we think about the audience that we will present our case to from the very beginning, from the very moment that either another attorney refers a case to us or a potential client reaches out to us directly.
Well, and of course, you have to start preparing the case for that ultimate end result if it ends up going there. And so does that shape what cases you bring on? Do you bring on cases that will probably settle, or do you have more of a mindset when you are vetting cases that you want those bigger ones that are going to be litigation cases?
Sure. I guess we don't really make intake decisions based off of whether we think something will settle early or easily. I don't think that that's something even a really experienced attorney can make a great prediction of early on. There are factors that you just don't know about at the moment of intake, that you don't find out about till down the road, till you start getting medical records, till you start getting insurance information, so you start finding out more about the incident and what happened. So it's really difficult to decide whether or not to take a case thinking, oh, sure, well, this will be one that I'll try and this will be one that I'll settle early on. I mean, I wish I had a crystal ball that could make those predictions for me. I'm sure every personal injury lawyer does. But that's why I find it helpful to just go into it with the game plan being, is this a case that if it doesn't settle, I'm going to be prepared to try to a jury? Not just any jury, but a jury in the locality where this happened. Because personal injury law, especially, you really do need a lawyer who's familiar with that locality. In the state of Maine, we've got 16 counties. Every one of them varies quite a bit from the others. And it's so important to understand the demographics, the case experience that different jury pools have had in each of the different counties. That's true in Maine, that's true in Massachusetts, that's really true of all the states that I have tried cases in. You have to immerse yourself in the locality to understand the audience that you're going to be presenting the case to.
Well, and it's understanding the audience and understanding how that audience relates to your client. And clearly that is going to impact how you develop your case, how you develop what pieces are going to be more important to a certain jury. And that's going to influence your jury selection. And all of these pieces have to work together. But first, you have to work the process, obviously, and working with the insurance company. So when you first start developing a case and working with the insurance companies, what is your mindset as you are speaking with them? What points are you trying to highlight and get across as you're navigating that first hurdle?
Sure. This is something that is really rapidly changing in this field because almost all of the casualty and liability insurance companies have adopted AI tools. And increasingly, you're having conversations with human adjusters, but and this comes across more sometimes than others, they're basing their analysis off of AI generated information. So it's so different from even 10 years ago when you knew a human being had gone through and had read the medical records and had read the demand and had really considered the human elements of the case. That just doesn't happen anymore. Now it is these AI tools that are going through the records, that are skimming through the demand package that you have put together, and then assigning their own sort of internal evaluation. So part of what you have to do to succeed in this day and age with insurance adjusters is not just talking to the adjuster, but talking to them in a way that will neutralize or address the AI sort of generated information that their internal casualty tools have put together about your case. I like to call this sort of the opposition research. So every claim, when we put it together now, we think not just about how I will talk to the adjuster about it, but how I will talk to the adjuster about what their AI tools probably told them about the claim, because AI gets it wrong. And you have to know the types of things that AI is going to misconstrue or overlook in your potential case. And when you call those out and when you actually say to the adjuster, like, hey, I know that you're saying blah, 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 but where in the records does that come from? Have you actually looked at those records? Because I have. I read every one of my medical records for my clients, and I know that quote, this information you keep parroting back to me, is not actually in there. That's an AI hallucination. That's not something that is actually in the records.
Well, and AI is clearly reshaping how so many of us do work, and it's clearly a big topic in the marketing industry. But AI as a tool throughout operations and case management, as well as on the insurance side, it makes us work smarter and it makes us work harder at the same time. Where not only, yes, it can take some of the labor off of our backs and kind of the mundane day-to-day tasks, but you need to still be very well versed in your cases. You still need to have that human eye on things and also have an understanding of how the medical records are going to be impacting the long-term care of your client. But Beyond that, which is, just basics of being a good lawyer, you need to also be really well versed in how AI works and what pieces the AI is looking at and how the different algorithm shifts might be working on the AI platforms, because it's not just assessing the medical records. It's not just maybe it had a hallucination about, oh, well, there was a multi-bone fracture versus a singular fracture. But it's also, have they plugged in a network of AI agents to also say, okay, well, here is the lowest possible settle amount that we think that this person will accept based on these demographics. And it's just going to get more and more sophisticated as time goes on, and very rapidly so. So as a good lawyer, you not only have to do the regular casework that you've always done, but you do need to be on top of how these emerging technologies are going to be making your job harder. And so with that in mind, how do you stay on top of the different changes in the AI landscape? And
Sure. I mean, it's not just important to familiarize yourself with the sort of personal injury focused AI tools, the ones that cater to plaintiffs' lawyers. It's also important to have an understanding of the tools that liability and casualty insurance companies are using. My goal is not just to convince an insurance adjuster that they're wrong or that their AI tools are wrong. My goal is to convince them that here is the information they need to go to their committee or their supervisor to get increased authority for settlement. My goal is to really provide the information that the AI tools are missing, the things that I know that these tools have a difficult time of pulling out and extracting of medical records, of analyzing photos. So many of the catastrophic injury cases that I work on are driven by just really graphic, horrible injuries. Yeah. And a human being can look at those photos and immediately know how a jury is going to look and react at those photos. An AI generator tool isn't going to be able to tell those photos apart from, a normal human body picture that has nothing graphic in it. So I always try to have an eye towards what is their AI missing? What is their AI getting wrong? And how can I neutralize that in a productive way that's going to make them think not just, oh, this is a plaintiff's lawyer trying to, put one over on us again, ha 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 ha, but rather that's going to think, this lawyer is making some good points. I think that this is something that our tools are overlooking, that this is something that warrants going up the hierarchy to get increased settlement authority to deal with this risk exposure here.
Yeah. And I think that that's so important. But let's say you've gone through that, you've worked the process, you've pointed out the hallucinations, and the insurance adjuster, the insurance company is still saying, no, we disagree with that settlement amount. And so now you have to take it to trial. So how now do you shift your approach in terms of communication and what's important as you move towards trial?
Sure. Well, fortunately, since I've been preparing for the possibility of trial since day one, it's a pretty seamless transition. But one of the things that I do think it's important to do early on is before you even start discovery, the medical record sets, the exhibits, the things that someday you're going to have to hold up in front of a jury. How do you want those organized? It's really easy just to say, well, we have them here. This is the way that we got them. And to not put a lot of thought and just to slap Bates numbers in those and to produce them for any discovery. But then you are, really hamstrung by that when you get down and into the courtroom and you've got a set of medical records that's completely out of order, that's got externals inserted within it. So I try to really make a game plan early on before discovery starts, once something goes into litigation, of how do I want this organized in a way and set out in a way that is going to be digestible to a jury. Because we ask a lot of jurors. We ask them to drop everything in their lives and to come listen to evidence in a courtroom about a stranger and to make a really big life-altering decision about that case. And it's important that we give them the information they need to make that big decision, and that we give it to them in a way that is not just going to be digestible by a medical provider or an experienced defense attorney, but a way that's going to be digestible for just a typical member of the community with no background in healthcare or legal skills, so that they can understand these big concepts in a way that makes them think about the magnitude of this loss for my client's life.
Right. And this is clearly a lot of these jury members' first time participating in this type of evaluation. And they really need to be able to have the information in a way that's easily digestible and easily understandable. And from this, you really have to think somewhat like a teacher, where you need to scaffold the information in a way that makes sense, but is also really convincing for that particular jury. So how do you shape and identify the information that is going to resonate most with the jury members?
Yeah, that's so important. I try to think of all the different learning styles that people on the jury have, just like any good teacher would, as you say. Some people are visual learners, some people are auditory learners, some people learn through discussion or repetition. And I try to make sure that my trial strategy hits on all of those different learning styles. There's something for everyone. Whatever your learning style is on the jury, I want to make sure that you're going to get this information in a way that you understand it. So instead of just documents, I'm also thinking, what are ways that we can use sort of color and shape and style to put together visuals, to put together diagrams or illustrations that are going to help people take this information back to the jury room and to put together the testimony that they've heard at trial into the way that I want to make sure they're thinking about it, that's going to maximize the recovery for my client.
And have you seen instances where lawyers rely on the same types of arguments and presentation style for every audience without really a whole lot of regard for different juries or different situations? And can you tell us, whether that fell short? What successes have you seen?
Sure. I mean, absolutely. You see some defense attorneys giving almost word for word just the same openings, the same closings. It's like they've done a Control F search and just replaced the name of the defendant and the name of the plaintiff. And I could see why, because there are elements of that are good strategies for defense attorneys to use. Just like there are a lot of good strategies for plaintiffs' lawyers to use in personal injury cases. But ultimately, since the burden of proof is on the plaintiffs, we have a lot farther to go to convince the jury. And we need to make sure that they actually understand what's happening and that they don't fall into any of the rabbit holes that are opened up by the defense. We have to put together a cohesive picture of the case. The defense just has to dig enough holes for the jury to get stuck in and mired down in, that they ultimately throw up their hands and say, we just don't think they met the burden of proof. So I need to make sure that for every rabbit hole that's being dug, that we have given them a bridge over that by understanding the information to get around it or to get through it.
Right. And those are all the logical elements that just need to be incorporated in any good case and the case strategy there. But clearly there are some things that are going to resonate more with jurors than some things are going to resonate better than others. And so in your experience, what do you find is the most impactful information to be sharing, whether it is visual, whether it is medical records? Is there something that you see that really hits the hardest when it comes to getting the jury to be on your side?
Yeah, Lindsey, it's funny. I think that so much of what really lands with juries is similar to what marketing information lands with potential clients. That makes sense. Juries are drawn from our community. So someone looking for a lawyer is going to be drawn to information that's presented in a similar way to a lawyer who's trying to present an injury to a jury. And so that connection to the community, really making sure that the jury sees that this is not just a nameless, faceless person who was injured. This was a member of our community, that this jury is empowered with standing up on behalf of the community to really speak as a jury of their peers to say that what happened was not okay and that this person needs to be compensated for what they went through. So I always try to present information about not just how this person's own individual life was affected, but how their life is part of the community, the people that depended on them, that they connected to, that care about them, how that wider web of sort of interpersonal connections were affected by this. Of course, there are always going to be sort of connections in the community. Everyone has those, but those things don't often get talked about at trials or even in lawsuits in the context of settlement discussions. I find that information is really effective at getting through to jurors, and it's really important to include, not only so that they understand the significance of the injuries to my client's life, but also because it helps juries understand that what happened to this person could have happened to any other member in the community.
Well, I imagine that that would resonate really deeply with the jury, especially in smaller communities where it wasn't just them, it could have been me. And knowing that this person was a mother or father, or they worked at a certain store that somebody might have frequented, this drives it closer and builds that emotional bridge where they have a deeper level of understanding than, oh, Sally had a broken bone and now she can't ride her bike anymore, but now she can't pick up her kid anymore and she can't drive to soccer games. And being able to broaden that identity so they can put themselves and insert themselves in that person's life, I'm sure makes a very deep impact on the jury.
Yeah, that it's so important to connect on that level with the jury, and that's why it's something we think about from the very start of the case.
Yeah. And so for younger attorneys or for attorneys who are new to a certain area, who may be developing their courtroom style still, how can they start thinking more intentionally about creating their strategy around their audience when prepping their cases? How can they really dig themselves into that community?
Yeah, you've got to get away from being a lawyer and get back to being a human. There's this real tendency I see with younger and less experienced attorneys to want to come across as a lawyer when in the courtroom, and they use a lot of legalese and they use a lot of phrasing that they learned in law school or on the bar exam or at the CLE. But ultimately, that's entirely unfamiliar to the jury. The jury knows that you're the lawyer. You're the only one seated up there at the table in the middle of the courtroom. You don't need to use big words or have long, convoluted phrasing. So I always tell younger and less experienced lawyers to forget their legal training for a moment when they're thinking about their courtroom presentation. What is going to resonate if they were explaining this to a family member or a friend who isn't a lawyer? How can they put these big concepts, this wealth of information into bite-sized pieces that someone is going to be able to follow and understand? And then how do you echo that again and again at the trial? Whenever I introduce sort of big legal concepts, I frame them and literally sandwich them between easy to understand words that I know anyone with a middle school education is going to get. So instead of talking about, the standard of care for negligence in a medical malpractice case, I start off by talking about, the safety rules, the safety standards of care. And over the course of the trial, you then start introducing that legal words, the things that they're going to hear in the jury instructions, pairing those up with the everyday language that someone has already heard. This is such a silly origin story for this strategy, but I remember one of my friends had a rescue dog that she had adopted, and she couldn't stand the dog's name, but it was the dog's name and it's what the dog responded to. And the dog trainer told her, what you need to do is start calling the dog the name you want, paired with the name she has. And you do that enough, and the dog starts realizing these things go together, and you can drop the second half and just keep the name that you want. That works in the courtroom too. You use the simple language, the simple phrasing paired up with the big legal concepts, so that by the time you get to the closing argument and you're having to go through and say, this is going to be your verdict slip, this is question 1, question 2, that doesn't have any of the easy words on it. That just has the pure legal instructions that the judge is going to be given. But by the time you get to that closing argument, you will have reached a point where you can drop the dog's old name and you're just using the dog's new name that you want the jury to understand.
Well, I thought that there are so many parallels between teaching and training, as well as trying to handle a courtroom and really maintaining control and educating and persuading. And all of these strategies work together to really inform and persuade the people that you are talking to. So I think that all of those tips that you shared are really great advice. So thank you so much. That's going to wrap up this episode of the Personal Injury Marketing Minute. And if you want to learn more about Elizabeth Kayatta, as well as the team over at Berman Simmons, you can find them online on simmons.com. And if you're a personal injury firm thinking about growth and strategy and messaging and audience awareness and how all of that fits into your marketing approach, reach out to me at Lindsey@optimizemyfirm.com. Thank you so much for listening, and be sure to like, leave a review, and subscribe so that you don't miss out on our next episode. Thank you so much again for joining us today, Elizabeth.
Thank you for having me, Lindsay.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.